The first big mistake, having the wrong trust structure. I'm going to spend a lot of time on this. It's kind of a little bit confusing, but I'm going to try to break it down in very plain English. 2, failure to safeguard your heirs. A living trust does not protect assets for future generations. 3, a failure to plan for special needs. 4, this is a huge one. Failure to update. Mistake number 1, having the wrong trust structure. Costly consequences of an AB versus a non-AB trust. This is for couples. A tale of fixing a trust. So Larry and Susan have a $3 million estate, including their home. Susan outlives Larry by 5 years. And by the time she passes away, when assets go to their kids, their estate grows to $5 million in value. Their children face over $300,000 in capital gains tax exposure. Wyatt and Jane, same situation, $3 million estate, including their home. Jane outlives Wyatt by 5 years, same thing. Estate also grows to $5 million, but because of a change they made to their trust structure, their children face 0 capital gains tax exposure when their children inherit assets. So that's a difference of $300,000 in potential taxes just from changing their trust structure. Tale of fixing a trust, a larger estate. So Ben and Ann have a $10 million estate. They've done very well. They've invested well. By the time that they pass away, if the second spouse passes away, I should say, it's grown to $18 million. Their estate ends up facing over $1 million in estate taxes. $1 million check has to be written to the IRS. Jacob and Sarah, same situation, $10 million estate. Their estate also grows to $18 million by the time they pass away, but because they made some changes to their living trust structure, 0 estate tax exposure. Now, before I uncover these mysteries, I'm going to take just a moment to introduce you or reintroduce you to a couple of really important concepts when we're talking about estate planning. One is the stepped up basis. So say you have a share of Google stock, you bought it $50 a share, now it's worth $100 a share. If you sell it, you have to report to the IRS, well, I paid 50, I sold it for 100, I made 50 bucks on that, that's your capital gain. Depending on how long you held it, you have to pay either short or long-term capital gains tax on that. It can be a punishing tax. It can be 30 or even 40% in some cases if it's a short-term tax. The key concept you have to understand, a lot of people are confused about this. Everything in your taxable estate when you pass away, my taxable, so anything that you own when you pass away gets a stepped up basis. This means that the IRS says, hey, if dad bought Google stock for 50 a share and now it's worth 100, if it was worth 100 when he passed away and then it goes to his kids, kids only have to report, if they sell it for 100, they can report a gain of 0. They don't have to report what dad paid for it. They only have to report what it was worth when dad passed away. It's called a stepped up, meaning capital gains taxes are wiped away as long as it's in your taxable estate. Applies to stock, to real estate, to other investments. It's a pretty powerful thing. Now, take one more moment just to introduce you to another key concept, the estate tax. Now, just how many families, what percentage of American families do you think are currently affected by the estate tax? Do you think it's 5% of families? Do you think it's 20% of families? Do you think it's 50% of families under the current law? 0.1 to 0.2% of families in America are affected. So it's 1 in about 1,000 families, because the exemption, the amount you can pass tax-free, is currently, and I mean currently, that's a crucial point here, $12.92 million. It's at a historical high. However, so you, unless you have, if you're a married couple, you can pass almost $26 million free of estate tax. Now, if you're single, it's up to about $13 million, but we have to be aware of the fact that unless major changes happen before then, on January 1st, 2026, the exemption is going to be cut by 50%. So it's going to go down to about $6 or $7 million per person. Your estate's hopefully going to keep growing in the next few years. Let's hope the economy turns around right as the exemption drops. And it's a punishing tax. Any dollar over the exemption amount is taxed at a 40% rate. So why is this all important? Because if you're a married couple, this has a huge effect on which trust structure is right for you. To AB or not to AB, that is the question. So just to take it one step back, revocable living trust, everybody should have these. When you create a living trust, just a primer, you have settlers. This is the people who create the trust, or also known as trustors. You have trustees, the people who manage the trust. You have the trust, and you have beneficiaries. So a living trust, you are almost certainly the settler. You are almost the trustee or trustees, and you are also the beneficiaries as long as you're living. And then after you pass away, your kids are. An AB trust is one of the two, broadly speaking, structures that couples can have. And when I say AB trust, this refers to what happens to the trust after the first spouse passes away. As long as both spouses are living, you can change the structure any way you want. When one spouse passes away, that's where the AB structure really comes into play. So let's say there's a couple with a $6 million estate. When the first spouse passes away, Remember about that stepped up cost basis? The entire community property estate gets a stepped up basis. The surviving spouse can sell those assets, pay zero in capital gains taxes. Now here, if you have an A-B trust, your assets are split. So $3 million would go into the A trust, the survivor's trust. $3 million would go to the B trust, also known as the exemption trust. Think of it this way: A above ground, B below ground. The A trust is under the full control of the surviving spouse. The surviving spouse can change its terms, change its structure, change beneficiaries, and then they have control of the money. Now, the B trust becomes irrevocable. The surviving spouse can't change its terms. Well, and that's an upside by itself. Some people like to know, hey, if I go first, I want to know that my wishes are locked into place. What if my wife gets remarried or something like that? It also gets permanent estate tax protection. Unless it's a very large estate, we'd have a more complicated structure. But in this case, that full $3 million is permanently taken out of the estate for estate tax purposes. So even if that grows to $10 million in the next few years, it's irrelevant. It's not going to be touched by estate taxes. That's a good thing. Let's say the assets have grown in value. Let's say the wife outlives the husband by 5 or even 10 years. The value of those assets are probably going to grow. When the wife passes away, assuming she's the survivor, the assets in that A trust get another stepped up basis before it goes to the 2 kids. So that's a good thing, right? And there's no estate tax exposure. Now, the assets in the B trust, however, when they go to the kids, they do not get another stepped up basis. Now, what's the alternative structure? Our firm calls it a continuing couples trust. You could also just call this a non-AB trust. So here, same situation, $6 million estate. One spouse passes away, full stepped up basis. Now we really have to administer the estate properly to capture estate tax protections. The trust continues. The surviving spouse has full control of the trust estate. $6 million in the surviving spouse's trust. It's revocable, and this is subject to estate taxes, but if it's under $6 million or so, and if we take the right steps when the first spouse passes away, we should be able to, even under the new law in 2026, we should still be able to protect $12 million. So we're not worried about estate taxes, but here the benefit of not splitting is that there's a full step up in cost basis when the second spouse passes away. There's more issues we have to be aware of than just this. But if you have a smaller estate, the EB trust is probably not the right thing unless you have other goals. If you're worried about the irrevocable nature of it, if you want to lock in your wishes, different issues. But from a tax perspective, it might be the wrong structure. In fact, it most likely is. And if you did a trust a long time ago, well, you probably have an AB trust. And capital gains tax, because that's our primary concern for most of our clients. Did you pay under $100,000 for your home in the Bay Area or Los Angeles or San Diego? I envy you so much if you live in California, because it's probably gone way up. And so you have a huge capital gain, and that's a huge issue. I think a general rule of thumb, and this is just for tax purposes, is that if you're a married couple and your estate is under $5 million, you don't want an AB trust. If your estate grows or as laws change, we might go back to recommending an AB trust. Larry and Susan have a $3 million estate, including their home. Susan outlives Larry by 5 years. The estate grows to $5 million after she passes away. Their children face over $300,000 in capital gains tax exposure. Wyatt and Jane, $3 million estate. When they pass away, zero capital gains tax exposure. Now, what's the difference? Well, Larry and Susan had an AB trust. So when Larry passed away, half the estate was put in this exemption trust. And when Susan, the second spouse, to pass away, the assets that were taken out in that B trust did not get another step up in basis. So their kids were exposed to $300,000 in capital gains taxes. Wyatt and Jane, on the other hand, he said, we don't need the AB trust. Let's simplify it. Full step up in basis when the first spouse passed away and another step up in cost basis when the second spouse goes. All the assets passed for the benefit of their kids with zero capital gains tax exposure, saving hundreds of thousands of dollars. Larger estates. Ben and Ann have a $10 million estate. It grows to $16 million by the time they pass, or maybe it was $18 million. Their estate faces over $1 million in estate taxes. Jacob and Sarah, they also have a $10 million. Their estate also grows massively by the time that they pass. And Jacob and Sarah, though, have zero estate tax exposure. Now, why is that? Ben and Ann did not use an AB, so they did not put the money in the B trust. So when the second spouse passed, the entire estate was exposed to estate taxes. They had $1 million owed. Sorry, Jacob and Sarah switched to an AB trust, which froze part of their estate from estate tax exposure years before. And when the second spouse passed away, zero estate tax exposure. You need to understand what trust structure you have, and based on the size of your estate and your goals, we need to take a look at it. We can very efficiently help you with it. So if you're married with an AB trust, now should you keep it? I think a general rule of thumb, if your estate is under $5 million, at least from a tax perspective, you don't need an AB trust. If your estate's over about $8 million, you almost certainly should have an AB trust in place. Now, if you're in between It's a gray area. We would talk about it and go through the trade-offs with you. And there are potentially hundreds of thousands of dollars in capital gains tax savings or millions in estate tax issues. I do want to flag, though, that it's not just about taxes, right? Life is more than taxes. Of course, we understand that. And even if you have a smaller estate, meaning still could be millions of dollars, an AB trust still might be right. Now, why is that? Well, what if you're in a second marriage? What if you have children from a prior marriage? What if you're just worried that, hey, if I'm older than my spouse, if I go first, I don't want my spouse to remarry and leave everything to this new family. I at least want to lock up part of the estate for my kids. So that's a case where, regardless of tax issues, you still might want an AB trust. Many families, I'd say, of the families we meet with, I'd say, who have smaller estates, I'd say 60 to 70% who had AB trusts from before end up switching, but not all, because there's other situations involved. And this is why you need to talk to a counselor with an expert. Of course, we can help you with that. If you are still around and if your spouse passed away years ago and you had an AB trust and your estate was split years ago, and maybe your house was put in a B trust and it's gone way up in value, if you and all of your heirs agree, we can actually undo an AB split that was done years ago. We can actually undo it. We can go to court and fix that. If you're confused or overwhelmed by all of this, and it's a lot, I get that. Living trust mistake number 2, failure to protect future generations, and really what you need to know. So this is the second big mistake we often see from people really who don't work with us, because if you work with us, we'd at least go over these issues, and some of our clients don't always do it up front. But I want you to take just a moment to think about all the sacrifices you've made to leave assets for future generations. Now imagine all of that hard work and all those assets you've built up, all the times you decided to fly coach instead of first class, or to stay in the mountain view room rather than the ocean view room, or to get the chicken rather than the filet mignon, or all those decisions, all those investments you worked so hard for, the lucky investments, the not so lucky, all those steps you took to protect assets and to hopefully build a safety net for yourself and for future generations. Imagine all of that, or a big chunk of it, being lost to an ex-husband of your daughter, or to a lawsuit when your son or your daughter is sued. A living trust, and this is where your living trust itself might not be a ticking time bomb, but thinking that it's enough, that could be a ticking time bomb, because your family could be met with some very rude surprises if they think that, oh, well, we have a living trust, we're good. The tale of supercharging a plan. I'm going to decipher what happened here, this mystery. So Larry's father leaves him $2 million. Larry, during his life, endures a divorce. He gets sued after a car accident. None of this $2 million that was left for Larry is there for Larry's children. And of course, nothing's there for his grandchildren. Wyatt, on the other hand, also inherits $2 million, or $2 million is left for Wyatt's benefit. Wyatt also gets divorced. Wyatt also gets sued, same life, but because of some different steps that Wyatt's parents took, Wyatt's children end up with $6 million from his inheritance, and his grandchildren end up with $18 million from that original $2 million. And this is where we have to think about the power of compound growth, because money that's protected, assets that are protected, have the chance to grow and grow and grow. And if they're just invested reasonably, they can double every 10 to 15 years. And compound growth is a powerful thing. So you might start off with a number that doesn't seem massive, and it can become massive if it's protected. A quick overview on trusts. Now, this is oversimplifying things, but they're generally 2 categories: revocable trust or revocable trusts, and irrevocable trust or irrevocable trust. The pronunciation always confuses me. My dad always says irrevocable, and I think it's irrevocable. I don't know. Revocable living trusts, whether you're a couple or single, do not protect your kids or you from divorce, from lawsuits. They can provide some protection from estate taxes depending on the structure, but not massive protections. They definitely don't protect from future property tax increases. You're thinking, okay, well, Mark, that's great, but you keep telling me to do a revocable living trust. You definitely need it. But I'm going to talk about the additional tools you need to take your plan to the next level. And what can we do here? So this is about taking your plan from the floor to the mountaintop. So imagine right now, if you just have a very simple estate plan, hey, you're on the road, you're moving forward. But how do you get to the mountaintops? How do you get above what most families are doing? Because most families aren't aware of this. How can you protect future generations? Don't leave them anything. Don't leave your kids, your grandkids a penny. And that's how you protect assets. Future generations. Not leaving assets to the next generation, well, I guess they're protected from some protection from divorce and lawsuits because they have no money from you. But that's not what I mean. You should not leave them even 1 cent. Instead, you should create a family protection trust for every one of your kids. If you have 2 kids, you should have 2 family protection trusts, aka Dynasty trusts. You should not leave money to your kids. You should leave them to Dynasty trusts, or our version, family protection trusts, for their benefit. There's no shortage of information out there about Dynasty trusts. You can Google it. We think every family, middle class, upper middle class, everybody should have the chance. Hardworking middle class families should have the chance to protect assets for future generations. Now, the general term dynasty trust, I get why people are like, whoa, because what do you think of when you think of the term dynasty trust? You probably have an image sort of like this, right? Like a gigantic mansion. Dynasty trusts are not just for billionaires, although billionaire families have been doing these for generations. We can all benefit from them. Well, there's 3 huge areas of protection. So if you're concerned about your leaving assets to your son or your daughter, and you're concerned about them getting divorced, well, assets, if you leave it to them directly and they commingle, 50% of what you leave them could be lost. If it's in a family protection trust, it's separate and it shouldn't be reachable in a divorce settlement. If your child is sued, if you leave money directly to them, it's fair game in a lawsuit. If it's in a family protection trust, there's a barrier of protection against creditors and people suing them. Now, nothing's 100%, but it's a heck of a lot better than having nothing at all. And this is really powerful. On the death of your child, and when assets go to your kids, and even on the death of your grandchildren, if you have these in place, the assets in the family protection trust, subject to some limits, are not touched by estate taxes. So let's say you have a child, maybe you're not leaving that much to your child, but your child's doing really well, and they have a pretty large estate. If they have a large estate and you leave them money directly, you just added to their estate, and everything you left them could be exposed to estate taxes, or maybe estate tax laws change in the future. The estate tax exemption could drop dramatically. So even if you don't have a large estate, if you leave money directly to your kids, that could get massively hit before assets go to your grandkids. If it's in a family protection trust, it is largely protected from estate taxes when your kids pass away and when your grandkids pass away, because here's the amazing thing. These trusts last for like 100 years. And you might think, okay, well, this is cool, but I don't want to tie my kids' hands. They're trustworthy. I think they can manage this. You can name your child to be the trustee of his or her trust after you're gone, subject to age limits if you want. It's really powerful. It can provide incredible peace of mind and protection for multiple generations. These last for about 100 years in California. So they can go for your kids, your grandkids, and even for your great-grandkids. And no, they are not just for the ultra-wealthy. And you don't have to just take my word for it. Michael Gilfix is obviously not here, but he just published an article in Bottom Line magazine. It's an amazing magazine that I read independently of this. And he wrote an article about the power of dynasty trusts and why families throughout America should really be putting these into place. So let's go back to that tale of supercharging a plan. Larry's father left him $2 million. He gets divorced. He gets into a lawsuit. By the time Larry passes away, $0 is left for his kids and, of course, nothing for his grandkids. Wyatt, on the other hand, that $2 million, by the time Wyatt also gets divorced, Wyatt also is sued. Same, imagine parallel life to Larry, same type of life situation. But when he passes away, $6 million there for his kids and $18 million for his grandkids, because Wyatt's father created a family protection trust and didn't leave a penny to Wyatt. He left it to a family protection trust for Wyatt's benefit. So when Wyatt got divorced, those assets were separate. They weren't commingled. They weren't lost in a divorce settlement. When Wyatt was sued, the person suing him saw that trust and said, I'm going to settle for pennies on the dollar. I'm not going after this. All that money was able to grow. It was invested reasonably. He used it to support himself, but it was still able to grow. Grew to $6 million by the time he passed. The trust continued through his children's lives. They were protected from divorce and lawsuits, untouched by estate taxes when it went from his kids to his grandkids, and it had grown to $18 million at that point, untouched by estate taxes. So that's where you have to think ahead. It's so powerful. And I hate to say it, but the families that are creating these now, when you look at generation or 2 generations ahead, they're going to be so far ahead of the families that don't create family protection trusts right now. And we don't want you to be left behind. And again, these need to be separate from your living trust. Once in a while, I'll see clients and they have a trust from a while ago and they say, oh, well, I have this terminology embedded in my living trust. So when I pass away, it sort of goes to these dynasty trusts for my kids. There are a lot of reasons why we do not believe that's a good approach. It should be separate entities, separate documents. You have your living trust and you don't leave it within your living trust with dynasties trusts within that. Is your trust a ticking time bomb? This is the other mistake, thinking that your trust will protect future generations from lawsuits, divorce, estate taxes, or from property taxes. So we need to be aware of Prop 19 in California. Could there be 1,000% increase in property taxes for your kids, for your home, for rental property, if you happen to have that? So Prop 19, what is it? It's a new law. It became law in 2021. It was passed by California voters. and it guts property tax protections for your home for future generations. I think one key area of confusion about this, and we saw this misstated in articles throughout the media, is a lot of people thought, okay, well, Prop 19 had some good things, lets you move within the state and keep low property taxes if you're over age of, I think, 55 or 60. That's not our focus here. Our focus is what happens when mom and dad pass away or when they transfer assets, transfer that home or that rental to the next generation. And a lot of people thought, oh, well, I get that maybe rental properties are no longer protected from reassessments, that Prop 13 protections are gone for that, but my home, that's safe, right? Wrong. Prop 19 provides limited protection for your primary residence and zero protections from reassessment for rental property or if you have a cabin or a vacation home or business property. So Prop 13 still exists. As long as you're around, your property taxes won't spike up, but for the next generation, they get hammered. A living trust will not protect your family from massive property tax increases. So that's another area where I think your living trust could be a ticking time bomb, because a lot of people think, oh, a living trust, safe, right? I've heard this from new clients. Well, I thought putting my house in a living trust meant there'd be no property tax increases when it goes to my kids. So I'm going to give a couple examples of how big these increases can be. For Prop 19 now looks at your property in two categories, your primary residence and everything else. Your primary residence gets some protections from property tax reassessments if your children move in to your primary residence within 1 year of you passing away. So if your kids inherit your primary residence, your house, and they don't live in it, they just rent it out, full property tax reassessment. Now, if they move in, there's $1 million in fair market value that's protected from a reassessment. So let's say you have a $2.2 million house, fair market value, and the assessed value is only $200,000, right? So if your kids move in, you take the $200,000, you add $1 million to that, $1.2 million is not going to be reassessed. But hey, the house is worth $2.2 million. That leaves $1 million unprotected. $1 million will be reassessed. Property taxes go up by about $12,000 a year. And if your kids don't move in, well, the full $2.2 million is reassessed. All other real property is fully reassessed when you pass away, no questions asked. Unless you take steps to plan, by the way. But we have a solution. We have developed solutions for families. We have the Gilfix and LaPole and Dynasty LLC process. So we can solve this. You have to plan ahead. So it's not just about taxes, it's about preserving your home, right? So let's say there's a $3.3 million value home and a $300,000 assessed value because mom and dad bought it decades ago. So Prop 13 kept the assessed value very low. Let's say the child inherits it and a child moves in. We thought we were protected, right? In this case, the first $1 million protected, but the house is worth $3.3 million. So you take $300,000, add $1 million to that, $1.3 million, that's protected. That leaves $2 million unprotected from property tax increases. So the difference, if a family does Prop 19 planning and keeps those property taxes low versus not taking steps to keep property taxes low, look at the numbers. They go up about $22,000 a year. And over time, over 10 years, that's $240,000. Over 20 years, over $500,000. Over 30 years, almost $900,000 extra property taxes. And property taxes are not fully deductible from income taxes. So to pay that extra $892,000 in property taxes, your child would have to earn $1.4 million extra dollars just to pay those taxes. So yeah, planning ahead can be so powerful. We're talking about hundreds of thousands of dollars, if not millions of dollars for future generations. Prop 19 has zero protections for rental properties. So no matter what the rental property, unless you take steps and work with us to protect it, it would be fully reassessed at fair market value. Let's say it's a $2 million rental property with a $200,000 assessed value. Similar numbers, by the way. If for a family that takes steps to plan versus not planning, we're talking about over $200,000 in after-tax money that you have to spend on property taxes over 10 years, $800,000 over 30 years. Now imagine if you have a child with special needs or you're worried your child won't be able to get a job because AI is taking over everything. That can be the difference between having a sustained future and not, right? It's a massive difference. So imagine what we can do when we work together to save your hard-earned real estate. We have helped hundreds of California families to protect their properties, their primary residence, and other properties from property tax reassessments. And we can still lock in the crucial step up in cost basis that we've talked about in other talks and earlier here today. There are many techniques using LLCs or entities where we can fully legally protect properties from reassessments. And if we use sophisticated trust planning as part of that, we can often still get a crucial step up in basis. So you don't want to give away your properties now. You don't want to use entities in immediately give it away to your kids. Don't try this at home. Do not work with somebody who does not understand these issues inside and out. And fortunately, Francis LaPaul on our team is, I think, one of the best tax attorneys in America, and he has developed some extraordinary solutions. There's no one-size-fits-all solution for any family. So, okay, do not assume your living trust will protect from property tax increases. It will not. A living trust mistake number 3, failure to protect a child with special needs. We give a lot of talks focused on special needs planning. Michael Gilfix and I co-authored this book, Special Needs Trust Creation and Management Guide. It is available on Amazon. It's available to our clients. But do you have a child on the autism spectrum, substance abuse issues, mental illness, physical impairment? It is crucial that if your child will have any inability to work after you're gone, that you do not leave money directly to them, that you work with an expert to create a separate special needs trust. And again, our book goes through how we think about this, but you don't want to leave money directly to them because they lose government benefits eligibility in many cases. And can they manage that money? Are you worried they can be taken advantage of? Are they able to manage it? So special needs trust really solves both of those issues. A diagnosis changes everything. If you've had a diagnosis in your family, you need to create a special needs trust. It needs to be part of your comprehensive estate and financial plan. Your living trust will not protect children and grandchildren with disabilities unless you add a separate special needs trust. So it has to be part of a comprehensive plan. And again, you do not, in this case, you don't leave money. Let's say you have a child with a disability. You do not leave money directly to that child. Instead, you create a separate standalone special needs trust for that child. Here it's Sarah. So mom and dad would not leave money to Sarah. They would leave it to a special needs trust, ensuring that someone they trust, a third-party trustee, oversees it for Sarah, and that the money doesn't count against public benefits eligibility. This is where it can be a time bomb. If you have, is your living trust a ticking time bomb? Well, you have a child with a disability and you have not created a special needs trust, or you created one a while ago and you think it's fine, you need to revisit it. The key thing here is if you name the right trustee, who's going to step in when you step out, who's going to step in and oversee those assets for your child or your loved one, to make sure they're not taken advantage of, to make sure that money is invested well, to make sure they're protected. Do you have an integrated legal and financial plan in place to make sure that your beneficiary designations are coordinated, that your investment approach is right? We're developing an integrated legal and financial program for select clients. Talk to us about that. And of course, don't work with somebody who dabbles in special needs planning. We work with hundreds and hundreds of families. I think we're the second firm in the state of California to do special needs trusts before they were even known as special needs trusts. And I'm very proud of our history in this area. If you have a child with disability, you do not want to have a living trust that has sort of a few paragraphs about how when I pass away, money will be held in this 5-paragraph structure for the rest of my child's life. That can lead to all sorts of problems, and it's very hard to update. So it should be a separate standalone document. I can't emphasize that enough. Your trust is a ticking time bomb if you think it'll protect your child with a disability. It will not. You need a separate special needs trust. Living trust mistake number 4, a failure to update. What you need to know to ensure that your trust is not that ticking time bomb. An out-of-date living trust can be worse than no trust at all. And I know we hammer this. Everybody needs a living trust. Everybody needs an updated estate plan. If you have one that's way out to date, there are cases where it can be worse than no plan at all. I want to tell a quick story about Heath Ledger. Really tragically, he died of a drug overdose in 2008. When he passed away, he actually had a simple estate plan in place. Here's the problem. He had not updated his documents in 2008. He last updated them years before his daughter was born. So when he passed away, there's millions of dollars in his estate. His daughter got zero because he set a plan, leaving it to the wrong people. He didn't have a kid yet. He didn't allow for that. He didn't work with somebody who knew what they were doing. Whereas we often can say, well, if I have a child in the future, we'll go to that child. And it ended up, I think, working out from what I read. The family worked together and they redirected assets. So it did eventually go to his daughter. But if there was someone who did not have a relationship with his daughter who inherited, that money could have been lost forever. So how is that relevant for you? Well, we need to understand you need to update your estate plan when your situation changes, as laws change. The documents that you create will govern what happens, even if they are illogical under the new circumstances, and even if they're obviously counter to what you would have wanted at that time. If you created documents 20 years ago and named somebody you now hate as your trustee or don't trust, maybe they're in prison now. If you name them, they're still named. If you don't update it, you're empowering the wrong people. So it's so crucial. Update your estate plan every few years. And here's a little checklist to make sure that your plan is up to date. First question I would ask is, have you reviewed your estate plan in the last 5 years? If the answer is no, probably time to take a fresh look. Of course, we can help you. Do you have new children in the picture? Do you have new grandchildren in the picture? There have been cases where we had clients who named specific grandchildren, they pass away, and they just forgot to make an update. So Half of their grandkids got money. The new ones that were born after they updated their trust got zero, or they didn't have the right trust structure. Do you have the right trust structure? An AB or non-AB trust? We talked in other videos and earlier here today about how that can have hundreds of thousands of dollars in tax implications, even if you don't have a large estate. If you have the wrong non-AB or an AB, depending on the size of your estate, that might cost your family hundreds of thousands or millions of dollars. Have you revisited who you've named as trustee in your trust and in your other documents? Do you even know who you named as backup trustees? I've had meetings with clients in the last month where the person they named as their first trustee, they are now embroiled in litigation against that person because they were friends when they created the documents and they are not friends anymore. And that is a disaster. More importantly, do you have the right backups? Are you going to be covered? The person you name, are they sick now? Are they just overwhelmed? Are they going to be able to serve? Have you talked to them about this? So revisiting trustees regularly is so, so important. And have you set up structures to protect future generations from divorce or lawsuits or property tax increases or estate tax problems? If any of these issues strike you as, ooh, I don't think I've done that. Hey, let's set a meeting. It's easy to review these issues very efficiently if we do it. But even if you don't end up working with us, you need to update these documents, and it has to be with an expert. And of course, we want to make sure that your estate plan empowers and benefits the right people. Have your children's situation changed? Is one of your children crushing it financially and another is really struggling? Maybe you want to redirect where assets are going. Is one of your children facing a new disability that they didn't have years ago? Do we need to add a special needs trust or other protections? Is one of your kids getting divorced and you're freaking out about what might happen if you leave money to them in the near future? Could that be lost to the ex-spouse? There's so much that we can do. We have something called the Peace of Mind program for existing clients. Some clients check in with us every year. Some clients come in every 3 to 5 years. Some clients, literally, I saw some in the last 2 weeks, the last time they'd worked with our office was like 2001. 4 key questions asked. Do you have an up-to-date estate plan, or has it been more than 3 years since you last reviewed it? 2, do you have a home or a rental property in California, and do you want to leave it for future generations? Hey, let's address that Prop 19 issue. Are you concerned about property or capital gains or estate taxes? Do you have the right trust structure? Are you aware of estate tax issues? We can very efficiently help you understand those or take the steps that you need to take. And do you want to protect assets for future generations from lawsuits or if you have a child with special needs? A living trust is not enough. That's where it can be a ticking time bomb, thinking that it is, or having an out-of-date living trust. And our team is not just me, by the way. It's Nick Klingenberg, Renee Conrad, Michael Gilfix, and Francis Lepold, our two principals. And we have over 120 years of combined experience between the 5 of us. And I think it's actually significantly more than that. Over 120 years of estate planning and elder law and tax planning experience. We encourage you to meet with us. You can contact us at 650-493-8070 or gilfix.com. I hope you got a lot out of this, and I hope everybody's staying safe, sane, and healthy. I hope everybody takes care. See you later.